Hi guys, hang on one second. Something just happened with my camera. I hope you all are well. Sorry for keeping you waiting. We stopped for dinner and it took longer than I thought it would. If you guys can hear me, let me know where you're coming in from so at least I know my audio is good. I don't know what's happening with this camera right this second. But on my side the readings look good for audio. Okay. What is happening? I'm gonna pull up. Show the comments. Hard to hear? Okay, hang on. How's that? Coming in a little louder? Temple, Texas. Oh, I hope you're safe. I don't know which is where in Texas, but I know. There we go. Wait. All right. Hi. Hello, everybody. Okay, so Donna had her hearing earlier, and I'm a little surprised by the judge's ruling, but we'll go through it. I'm just going to summarize it at first. So, for those of you guys who are into dates, he did extend their time to file motions until the 21st of July. And then their final pretrial hearing is going to be August 8th. The trial date has not changed. And they did not hear the motion for not for Sigfredo, for Luis Rivera. They're going to hear that on the 8th. He did hear the motion for her data not being through a filter team. And sorry, I think Sugar Bear is turning the TV up in the other room. Give me 1 second. I'm going to run the intro and then I'm going to close my door. Happy Friday, everybody. Hello, true crime lovelies. I'm going to thank the members and I'll see you on the other side. Alrighty. Hopefully you can hear me better now. Doors closed. I just turned up the temperature on the AC, so hopefully it'll click off and you guys can hear me okay. Let me just check. I'll make myself a little bit louder. If it gets too loud, let me know. So yeah, I did I think on Wednesday, the video about where they were basically calling the state a liar and saying they didn't fill out the documents correctly. And Sarah Dugan was the one that was responding to those emails, right? That was submitted as Exhibit A by Donna's defense team. But Georgia Kappelman is the one who came into court. I love them both, but I just Georgia is everything. So she showed up. So we'll see her in the video. And basically, they're saying they're hemming and hawing about, the discovery. So the judge was very pointed, when do you need? I think he called it Jello. You'll see. I'll play the clip. I'm just going to summarize it because some of you guys may have seen it, not seen it. I'm just going to recap it and then it's a short clip. It's 18 minutes, so we won't be here all night. But basically it was it's Jello. And then he rephrased it. Josh Zellman rephrased it as a moving target, but Jello is very different than a moving target, sir. And so what they were saying, what basically he's asking for is more time after the state submits all their discovery, which is not exactly how it works. So they landed on the 21st. So a week from Monday, everything has to be turned in. He did say he would leave for them to make amendments to those motions, but they all needed to be filed. But basically, Zellman's answer, he still didn't give a time, which is why the judge came up with the 21st. He was like, well, I need all of their stuff and things keep popping up. And then he said, well, what are the motions going to be about? and its discovery. That was just like vague. So he did give an example, like they had recently, I think, had a deposition with Corbett, and they learned that there was more data that Corbett used to create his presentation that they did not have previously. And so now they want that source data, which makes sense. But then Georgia came back and was like, that's not really a discovery violation. Like, we gave them the report. And, obviously the prosecutor doesn't know exactly how Corbett made up his report. And so it wasn't like an intentional omission, which seems to be what Donna's team keeps implying. So, who is this? I found the Joshua E. Adams Dayton beat, and I think minions are bouncing around the letter so people don't know where he's stationed. Joshua E. Adams, that's for Sarah, right? He has an address on the Florida State. We'll get to Sarah in a second because I have some comments, because you guys had a lot of comments on the last video with the future Sarahs, and you get to be, oh my God. Okay, so I want to share my screen and we can get into this with what happened today, because it was interesting. I haven't given away the tea on what he decided for whether it's redacted or not, because I want to do it in time. I was surprised, but then after I thought about it, I was like, this makes sense. It's similar to what happened at the very beginning when they had to get rid of Rashi. Although I would think the judge would want more receipts for them, because I feel like he trusted Rashbaum too much, right? In saying that he had, that Charlie had waived, and then it wasn't in writing. So I'm curious as to what you guys think, but let's get through it. Okay, share. I'm gonna put myself in the bottom here. Ooh, not that big. Oh my God. Me and these. Okay. I hide the comment. Perfect. And then the audio was low for me earlier, so if it comes in low for you guys, just let me know in the chat and I'll do my best. I don't have a soundboard or mixing board, but I'll do my best. Oh, and Donna has chopped off that raccoon tail that she had going on. It looks better. It doesn't look good from this angle, but when she leaves, it looks good. I think she needs a round brush. Not that anybody asked me.
Hey, Judge.
We're here this afternoon in the State versus Donna Adelson, 2023 CF 3226. Two motions we're here for this afternoon would be the defense's motion to compel and also the defense's motion to extend previously ordered deadlines for witnesses, exhibits, and pretrial motions in completing discovery. Part of the reason I believe we need to have a hearing on these matters as well, and I'll let you make your argument in just a moment, Mr. Zellman. Have you discussed with your client specifically as it relates to the raw data that you are seeking, specifically for Charles Adelson and herself, that this has the potential to reopening the door of the conflict?
Your Honor, I don't think that it would. It's in the same category as the emails that Your Honor authorized us to obtain in April, the raw, unredacted, unfiltered emails from our client's own account.
While they are certainly discoverable and while you have an interest in using them to prepare for, the question remains, have you discussed with your client the possibility of this reopening the door to any conflicts?
No, we have not, because I don't think that it would reopen the door.
Very well. You may make your argument.
So, Your Honor, you may recall a number of times we've been before the court and the defense, and as laid out in the motion to compel, we have been asked.
So that is the weird part, because we know in Sarah Dugan's email, she has said there are conversations with Donna and former counsel, i.e. Rashbaum. So for him to stand up there and say, I didn't discuss it with her because I don't think there is, it's just giving me flashbacks of Rashbaum. And I think Judge Everett has done a really good job of walling off those things. So I feel like maybe he's giving them enough rope to hang themselves, but let's get to his ruling. What do you guys think? Like, why? And Judge Everett has that motion. He has the exhibit where Sarah Dugan is saying there's attorney-client privilege with Rashbaum, and they basically be like piercing that veil. I don't get that part. And just, it's a bold-faced lie when he was like, well, I guess it's not a lie because he said, I think it is, and he could go back and say he was mistaken. But it's a slippery slope.
For the raw, unredacted downloads, the emails, and we were repeatedly told that that had been provided to us. When we were able to retain a independent forensic data expert and provided them with the materials that we had been provided, we were informed that those are not the raw forensic extractions. And I was asked to obtain.
So just like he didn't know, right? He got it, whatever, in April. How does he know? He's assuming the prosecutor knew, right? When he looked at the data, he couldn't tell. He couldn't discern that it wasn't raw, unredacted. It wasn't until he got his expert. So, I mean, one could argue if you got it back in April and your expert's just now finding out, what is it, April, May, June? It's like we're in July now, but 2 months. So I feel like he's being disingenuous to imply or infer that somehow the prosecution was being dubious.
The raw forensic extractions. And in the motion to compel, I actually cut and paste the expert's explanation. I'm not going to try to paraphrase it. It's an explanation that he provided as to why it is his recommendation that we obtain the raw forensic extractions. That's what I did. I've requested that. It's taken, we're now at a month since I made that further request, and I believe that we're entitled to that. I think the rule provides that, and our intent in part is to verify the cell brights that the state has prepared. The only way to do that, according to our expert, is to obtain the raw extractions from the state. And that's why we're asking for that, Your Honor.
Ms. Kappelman, you may respond.
No objection, Your Honor. I would just ask that whatever reports are generated by their expert as a result of that data being re-cell-brighted be provided to my office in a timely manner, because I'm advised, based on the version of the program and type of program they use to produce a report to verify our report, there could be some small differences involved. So I would like to not be surprised with that at trial.
Well, as to that, I will grant the defense's motion to compel. As to the issue of the conflict, specifically, Mr. Zellman, in part, when we had the first case management, I had counsel verify that they had no conflict as far as giving conflict-free representation to Mrs. Adelson. Should anything change with your review of these cell brights that may include communications from prior counsel or deal with matters that pertain to information that was provided by Charles Adelson, at that point, we are going to have to revisit the issue. Does everyone understand those?
Yes, sir. May I approach with a proposed order?
So this is what he's trusting them, in my opinion, too much. I know we're saying he's one step ahead of them, but what if they uncover it and then they don't disclose it? They're already accused of letting Donna use their phone. Do you know what I mean? And then also that just throws it all back in jeopardy. That means she's got to start completely over. I don't understand like why. I mean, I guess they're trying to save money by not getting a filter team. I don't know how much time it takes. Maybe it's a time and money situation, but I just feel like why not be safe rather than sorry later? Because let's say they do discover some stuff between Rashi and Charlie, or because you're getting both. They want Charlie's emails, they want Donna's emails, they want all of Donna's data on her phone. They only have Charlie's iCloud account. I mean, I guess there could be photos, but you know what I mean? Like, why risk it? I feel like don't trust them so much. I don't know. I mean, I know he knows what he's doing. I would be like, get the review team in place.
May.
Okay.
Thank you.
And Your Honor, just to advise the court, Mr. Corbett and the defense expert have been communicating over the last 18 hours or so that once that order was signed, Sergeant Corbett was going to upload that to a portal that they've already tested this morning, so that our expert can download it. That'll be the fastest way for them to do that. He said as soon as, Sergeant Corbett indicated that as soon as he was given instructions to start the process, he would do so.
Right, as to the second motion, the extending of all deadlines for the defense. In particular, we've already had 2 extensions that have been provided by the court, first from the April 30th deadline, second from the May deadline. Does the defense have any motions that are unrelated to the new discovery?
No, Your Honor.
All right. As to the motions that you believe you still need to file that are in some way related to this discovery, what is preventing these motions from being filed and you seeking leave to amend as necessary?
Your Honor, due to scheduling, we were only able to depose Mr. Newland and Sergeant Corbett Wednesday, Thursday. We are deposing Special Agent Pat Sanford, I believe, on this coming Tuesday. Before filing those motions, I think it's appropriate to make sure that there's a good faith basis to do so. And having those depositions, that testimony is, in my opinion, is necessary before we do that.
Right. And I believe there are some other depositions that are scheduled for July or I believe next week as well.
Yes, sir, we have them on Monday.
There's like 6.
Tuesday and Thursday.
Part of the reason that we have, whether it be discovery or any sort of deadline cutoffs in any case, is not simply arbitrary of the judge just saying, get it done by a certain date. It is so we can proceed orderly to trial. I believe your proposed dates were to within 4 weeks of when you believe the state has fulfilled its obligation. That's when you would want to file your motions.
Well, Your Honor, given that we filed these on June 27th, we're obviously 2 weeks past that.
Oh, yes, we are.
And it's certainly not our intent to do anything to delay the commencement of the trial as scheduled.
The
Really?
proposed
After 2
date of when this
extensions?
would occur is not specific. It's not certain. It's pretty much a moving piece of jello. Is there anything that you can do to convince me that it's otherwise going to be a specific date and what you're asking to do with filing these motions several weeks after you believe the state has complied?
Unfortunately, it has been a moving target because we have not received all of the discovery from the state.
Blame,
During
blame,
depositions,
blame.
during yesterday's deposition, we learned that he had conducted call frequency analysis between Donna Adelson and Charlie Adelson for a longer period of time than that had been previously disclosed. He is going to send us that if he had completed a report. He's also sending us the PDFs of the actual call frequency analysis that is contained in the demonstrative, because those are just excerpts of the call frequency analysis. So he's going to be sending us the completed call frequency analysis. So I say that to demonstrate that it is difficult for the defense to file any appropriate motions or to provide appropriate responsive either demonstratives or exhibits when we still have not received everything from the state.
At the same time, to file, and how many motions are we talking about at this point?
Potentially 3, Your Honor.
As to these 3 motions, would any of them affect the ability to actually move forward with the trial on August 19th?
No, I don't believe so. None of them are just positive.
Very well. Do you have any further argument in support of your motion?
No, Your Honor.
Ms. Kappelman?
No objection, Your Honor. We've just asked that we be given the same grace. I'm aware of at least one or
That's
2
fair.
more things that the state intends to do that could, need to be done past the deadline. So all indications are that both sides are working diligently to get this done. I understand your comment about the Jell-O, and I've got a couple orders myself of Jell-O that I'm wrangling, so I'm trying to minimize it, but things do come up past the deadline, so we're going to have to work
Ms.
through those
Kappelman
things.
specifically asked these emails, which has contributed to this. What is it else that you believe is going to come up on the state's behalf?
The emails?
I said, other than the emails,
Oh,
what do
What
you
do I
think is
think
going
is
to
going to
come up
come
on the
up? There's
state's
a
behalf?
defense witness that's been listed that the state has discussed trying to depose and may try to get that done before the deadline. There's a handwriting expert that the defense is aware of, that a handwriting expert exists, but they haven't been given the name or the report yet. I don't have the report yet. So that's something that's pending that would be in violation of Your Honor's order. So there are a couple outstanding issues that I'm aware of. I was not aware of the issue that the defense just brought up regarding Corbett having done a report, but he does do work to generate the slides that were prepared and discovered by the discovery deadline. When asked about how did you come to those conclusions in deposition, he's going to say, I looked at the data. Well, they want to see that data. Okay, we don't object to that, but I don't think that's the same thing as a discovery violation.
The final pretrial hearing is August 8th.
He's like, yeah,
As
yeah.
to the date of when all motions need to be filed, so we can have a meaningful hearing on August 8th and proceed to an orderly trial on the merits. These motions are going to need to be filed by July 21st. Any motion that is not filed by either the state or the defense by that date, the issues are subject to being deemed as waived. If you need to seek leave to amend as to the specific motions that will be filed on this date, you may certainly do so. However, again, this is not just arbitrary date making to throw something out. If we are going to in fact have a trial on the merits that will be orderly, both parties needed to see what you intend to raise as pretrial legal issues that the court needs to rule upon. There's not going to be a trial by surprise either for the state or for the defense. Am I making myself clear?
Yes, Your Honor.
Yes, Your Honor.
Will you state those dates one more time? Motions to be filed by July 21st, and
21st.
final motion hearings on August 8th. Is that correct?
The final pretrial hearing is on August 8th. This time has already been set apart by a previous order. As to the motions in limine that have been filed, I believe the defense has renewed its motion concerning the Latin Kings. Is that correct?
Yes, Your Honor.
Has the state filed any motion in limine by the previous deadline?
We renewed motions that were filed previously. There's nothing new.
Well, as previously ordered, copies of all of these motions, when they are filed, they need to be served upon the court. Please do so if you've not already done that regarding what has already been filed.
Georgia got a wrist slap. We forgive you, Georgia.
I believe the next date that we will have, unless there are other issues that need to be addressed, will be August 8th. Does either party have anything it needs to raise?
Nothing from the state, Your Honor.
Can I have a moment, Your Honor?
Go ahead.
Her hand on his neck makes me feel like she's like trying to push him down. I don't know into what, but I'm like, listen. Oh my goodness. Yeah, so I feel like there should have been a review team. He should have ordered a review team just to keep everything cool and copacetic, because this is what happened with Rash Bomb when we didn't trust but verify that Charlie had signed a waiver. And then it came back. I thought I had it. We couldn't get it. Now he's changed his mind.
Well,
Like,
we
why
are
was-
recessed for this afternoon.
Thank you, Your Honor.
Thank you, Judge Everett. Yeah, he is not trying to go back and tell Miss Everett that trial is not happening on that date after two.
Yeah, go ahead.
Let's see if we hear anything juicy. So watch when she walks out. Her hair looks good from the front, and she has that nice old lady gray streak
What's
here.
that? It's good to file as is.
See there, it looks okay. I think she just needs a round brush, maybe some deep conditioner. Do they have that in jail? But I think just a good brush.
Holiday, Judge?
Oh, the weather was good in both Maine and Canada. Could have been cooler, but it was nice.
Oh, he went to Maine and Canada. Wonder if he went to Nova Scotia. Okay, so while we were all sitting here, thank you for being here, by the way. I appreciate you guys. I was trying to look up the deposition so you guys could see how many they have, and they're going out until like the 18th. And I found out he has ruled. Oh, I'm thumbing up myself. You thumbs me up if you're liking this video. He's ruled on the venue change. So we're going to go through both of these right now. I was trying to upload them to Dropbox so I could share them. First, we'll do the, oh shoot, did I accidentally close it? I did. Depositions. Let's do the depositions first. So you guys can just see how many they're asking. I think it's a little overkill, especially after he was. Imagine if he hadn't put the restriction on the depositions. Let me say it like that, because I think this is ridiculous. But I don't have a lot of patience these days. Wait, so maybe you guys think it's okay. Show toolbar. I want it to be a little bit bigger. Hide toolbar. Okay. So Drina Bernhardt is July 14th, which is Monday. That is the alleged inmate that Jonna was paying off to testify, and who has the script according to the exhibits they're going to enter, whatever the evidence log that they put in, and witness list, right? Brittany Adams, I don't know who that is. Josh Turner and Patricia Bird, I don't know. But the 17th, let's see, if Monday is the 14th, the 17th is late because they have to get everything in by that next Monday, the 21st, right? So the 17th is Thursday. So that means they're going to be up all night and all day, probably all weekend, all day Friday, Saturday, Sunday, getting whatever motions in by the 21st. So it seems like a fool's errand, but, Donna likes living on the edge. Okay, let's get into this. Can you guys see this? This came in, oh, it says 7-8, but on the docket it said 7-11. Maybe they just, I think they hold it. I don't know. Anyway, order on defendant's motion for change of venue. Okay, what do you guys think? I think she's gonna say no. Hear me out. Hi. As far as I know, it is open to the public. I think Barry said that if it wasn't, they were going to put out oh God, where's StreamYard? They were going to put out a notice to check the website. But the last I heard, it was open and Sarah was ordered to be there in person. And they sent over, I haven't seen the official transport order, but in the court minutes, Sarah was ordered to be there in person. But if I hear anything different, I'll definitely let you know. I still am waiting on my license. So I finally got my birth certificate. I'm going to AAA next Friday to get, so I can't fly yet anyway, so I haven't booked my ticket. So before I book it, I will let you know. I'll email you. Okay, let's get into this because I didn't think this was going to happen until after they started to attempt to, hold on, one of the dogs is growling. Let me just make sure she's not growling at Sugar. Are you playing with Justice? Why is she growling?
What?
Yeah, was she growling at you? Okay, sometimes he's rough with her. He thinks it's funny, so I just have to make sure everybody's alive. Okay, I did not think he was going to rule on this until after they tried to seat a jury, just based on what he said. But I do know that last week, the defense filed an addendum to their motion for change of venue. I couldn't see it. But I saw that there was a filing on there. Anyway, let's see. So order on defendant's motion for change of venue. This cause comes before the court, filed January 14th. Court having considered the motion, accompanying memorandum of law and affidavits, reviewed the record and accompanying exhibits, held an evidentiary hearing, and being otherwise fully advised, hereby finds. So I'm not going to go through the background. We all know she's accused of murdering her son-in-law. So the state, let me just do, nearly 3 months later, she filed an accompanying memorandum of law in support of her motion, along with multiple exhibits. Not 3 months later. And he's saying it was prompted by a temporary unsealing of an in-camera transcript, i.e. the Rob Adelson transcript. I think there might have been one before that. I feel like Brother Counsel had one. It might be this one, though. But I know Brother Counsel he was quick and put up the video, and then the motion was taken down. Okay, sorry. Am I in your way? Okay, I'll pick you up. The state opposes defendant's request at this juncture, insisting that the only way to determine whether an impartial jury can be impaneled in Leon County is by first attempting to impanel an impartial jury. And we all remember that epic cross that Georgia did with their quote-unquote expert, their Kohlberger expert. Is it Kohlberger? The one who just pleaded guilty. Analysis. To prevail on her motion, defendant has the burden to demonstrate that the setting of the trial is inherently prejudicial because of the general atmosphere and state of mind of the inhabitants in the community, Manning Beef State. More specifically, the test for determining. Yeah, are you helping me out? Okay. Justice. Uh-oh, I feel like it's about to go off the rails. Let's focus in. Deep breath. The test for determining whether to grant a change of venue is whether the inhabitants of a community are so infected by knowledge of the incident and accompanying prejudice, bias, and preconceived opinions that jurors could not possibly put these matters out of their minds and try the case solely on the evidence presented in the courtroom. Griffin v. State. Florida Supreme Court explained in Manning that a trial court could determine whether to change the venue for a trial prior to commencement of the jury selection, or a trial court may withhold making the determination until an attempt is made to obtain impartial jurors to try the cause. So that's what I was thinking we were going with. As often occurs with the passage of time.
Oh no, he did it.
Oh no.
Oh no, keep it,
Okay.
keep it.
As often occurs with the passage of time, legal precedent on a subject evolves.
Mama.
Yes. So remember, Donna's defense came in with citations from what did we say? The 50s? The most recent ruling from the Florida Supreme Court regarding a change of venue requires a trial court to make a two-pronged analysis. Trial courts are to evaluate, 1, the extent and nature of any pretrial publicity, and 2, the difficulty encountered in actually selecting a jury. Smith v. State, citing Griffin v. State. Emphasis added. There are various factors. Okay, let's go through this. One of those factors, whether the defendant has exhausted all preemptory challenges, even necessitates proceeding to prong 2. The critical inquiry for prong 2 is whether any difficulty encountered in selecting a jury. So we haven't gotten that far. So we haven't met either one of those prongs. Reflective of pervasive community bias against the defendant, which so infected the jury selection process that it was impossible to seat an impartial jury in the county where the trial was held. Quote, Rolling v. State. Both the extent and nature of the pre-trial publicity and the difficulty actually encountered in selecting a jury are critical factors. So I think they demonstrated, or partially demonstrated, to be fair, with the expert. Okay, honey. Can I rock you?
Yeah.
Okay.
I like you.
Okay. So I think their expert partially demonstrated that, except there were no geolocations on it, right? So we have no data to say that it was specifically in Tallahassee. They showed what evidence was kind of out there, but we talked about this. Like, we're on YouTube. It's worldwide. It's not like just honing in on Tallahassee. So they had no quantitative or qualitative, in my opinion, data to show that the specific people in Tallahassee were tainted. And I know they showed some of Miami, which they never explain why. I mean, we know that's where Donna's from, but they never, like, again, no geotags to say less people in Miami have been infected with knowledge than Tallahassee, right? So it's a little strange. And they do it by percentages. So it doesn't matter that Tallahassee is smaller than Miami because we're going by percentages. So that data was just flawed anyway. And it was combined with Donna and Charlie, and we could not separate out Donna. He could have done a pivot, but he was like, he didn't want to do it on the spot. But I mean, that should have been readily available. Someone was going to ask, what about just Donna? Okay, so defendant would have this court reject these binding precedents and turn this into a one-prong analysis. The court declines to accept this invitation, which is fair, right? Because if he ruled that way, there is no precedent, but the state does not have an appeal right. In this, Donna could go back and appeal, like, to an appellate. I mean, she's already done it, trying to get the judge recused. So I think this is fair. Although it is undisputed that this case contains extensive pretrial publicity, undisputed. Pretrial publicity is normal and expected in certain kinds of cases, and that fact standing alone will not require a change of venue. Griffin. Therefore, Section 91003, Florida statutes, and Smith, along with its related precedents, compel an approach that includes voir dire of the inhabitant. So the people of Tallahassee need to be voir dired first, where the crime is alleged to have been committed. That's got to be the first step. You can't just jump out. And I think, like in the Kohlberger case, is it Kohlberger or am I hungry? Or whatever. The Idaho case, there was also an infrastructure issue, right? They moved it, part of it, because they didn't have the town didn't have the infrastructure to support the amount of traffic that was going to happen, because not just traffic, but the people coming in, right? Not just car traffic, but the amount of people coming in, the size of the courthouse, the security that was needed, etc. You guys know what I mean when I say infrastructure, right? The second prong of the analysis requires the trial court to examine the extent of difficulty in actually selecting an impartial jury at voir dire. And that's also where they would get their challenges, right? We remember Charlie talking about his strikes on the phone, and like he was striking for people that shouldn't. He felt like he was striking for people that he could not allow in the jury, and the state was striking for people that would be in his favor. But that's where you get your say of like, oh, I don't think that person would be a good juror for me. Defendant's approach also, and he paid $1 million for that. Defendant's approach also ignores the long-standing principle that jurors with prior knowledge or even preconceived opinions as to the guilt of the accused can nevertheless serve on a jury if they can set aside their beliefs and render a verdict based solely on the evidence presented at trial, right? So we talk about this all the time. Just because they've heard of it or just because initially they thought someone was guilty does not preclude them. They have to say whether or not they can set those preconceived opinions aside. And if they can, and like hear the evidence for what it is, then they are eligible to be seated on the jury. So it's not like you have to have never heard of it. So just the fact of publicity alone is not enough, because you could have heard of it and not formed an opinion at all, or been like, oh, that's interesting, or like, oh, she sounds guilty. But then when asked, like, once you hear all the evidence, the facts, would you be able to set that aside? And some people can, they're honest. Some people just don't want to be on a jury. They'll say anything. To hold that the mere existence of any preconceived notion as to guilt or innocence. Okay, he's just quoting that. I'm going to skip down here. You guys, if you want to read it, you'll be able to come back and stop and pause. As a result, it is possible to impanel a jury comprising persons who can be relied upon to decide the case based upon the evidence. And it's sort of parenthetical, the evidence presented at trial, not what they heard on YouTube. Okay. And not be influenced by knowledge gained from sources outside the courtroom. Okay, I jumped the gun. Then a denial of change of venue is proper. Defendant has provided no legal basis to forego the essential task of asking prospective jurors whether they can be impartial, right? So we got to do at least voir dire. Despite any potential, don't do that, extrinsic knowledge about this case, along with other vital questions. Furthermore, it's always good when you get a furthermore. The court finds the hearing evidence does not demonstrate that the extent and nature of pretrial publicity is so pervasive that attempting to seat a jury would be futile. Yeah. So you paid all that money for that expert and got wah, wah, wah. Can you say that? Wah, wah, wah. Wah, wah, wah. Yes. Wah, wah. The court is mindful. Conclusion. The court is, sir, can you get your monster truck off my keyboard, sir? Hold on. Conclusion. The court is mindful that nearly 70 years ago, the Florida Supreme Court declared that every trial court, in considering a motion for change of venue, must liberally resolve in favor of the defendant any doubt as to the ability of the state to furnish a defendant a trial by fair and yes. Yeah. By a fair and impartial jury. So that 1959 quote that they were relating on, I think Judge Everett said it was like his father's age, is no bueno. However, the defendant has not provided a sufficient legal or evidentiary basis for bypassing the Florida Supreme Court's two-pronged analysis regarding a change of venue. You did not meet the threshold, ma'am. Lump sum of traditional media coverage the defendant cites in her motion draws factual information from court records and proceedings. You want some lemonade? Do you want lemonade?
Yeah.
Okay. Defendant has not shown how the local reporting that comprises her evidentiary hearing exhibits is any different from cases where a change in venue was not required. See Foster v. State. Voir dire is appropriate for excluding prospective jurors who have been otherwise exposed to any inflammatory content. Also, can you imagine if he waived voir dire and let them do it? Like, he would be setting a weird precedent, right? Like, that would be carte blanche for too many criminals in Florida. Moving jury selection from Leon County based on the current record before the court would reject the capability of all prospective jurors to set aside any preconceived notions or opinions and assure that their verdict will be based solely on the evidence presented. Okay. It would also discard the quote, firmly embedded principle of criminal jurisprudence that a person of a crime must, as a general rule, be tried in the community where the alleged crime took place. And that's fair for the community that they have, like, those are, I mean, the community is who was impacted by Dan Markel's murder. It's fair that they be able to sit in judgment of the person accused of murdering him. Without first assessing a critical factor in the analysis for changing a venue, Carter. This also does not mean that defendant will be unable to raise the issue of venue following voir dire. So let's get to voir dire. If there is an actual issue, then we've met the two prongs, right? She'll have had her challenges, although, yeah, she'll have had her challenges. I don't know, though. Can you tell if your challenges failed or not? But I mean, I don't know. That's kind of nebulous. I don't think her case is strong enough to win. So it doesn't, like, how do you determine? I mean, I guess they could complain and say, we ran out of challenges. I'm not sure. What do you guys think? It simply means it is too soon to determine whether a change of venue is justified. So he's not saying no, but he's saying we're going to at least try and seat this jury. Similarly, the court declines to grant additional, I don't know, additional preemptory challenges after she has exhausted the number afforded to her by law. She's asking for all kind of favors. So not only do they want it moved, but if we have challenges, we need extra because our client is extra guilty. We need to get rid of some other people. A trial court in its discretion may grant additional preemptory challenges. There is a right under Florida law to a certain number of preemptory challenges, but there is no right or entitlement to additional preemptory challenges. Uh-oh, Donna's losing her entitlement. No entitlement for you here, sis. Beyond those established in section 91308. No, what? No. So, order on a judge, the ruling is reserved on the motion for change of venue. Defendant may renew her motion following an attempt to actually select the jury. A change of venue will not be granted unless defendant can demonstrate both prongs of the applicable Florida Supreme Court test. It is further ordered in a judge that ruling is reserved. That ruling is reserved.
Oh no.
On defendant's request for additional preemptory challenges until after she has exhausted the number afforded by law. So we're going to try to seat it in Leon County and you don't get any extra challenges. We're going to just try it the old-fashioned way first. And then if you're able to prove that that didn't work or it proves out just by the way it... Oh no, give me this. Okay. Let me see. All right, I'm not going to chase you. Oh my goodness. Okay. So I just think, yeah, I'm not surprised. Yeah. So yeah, it's reserved. But he's saying we're going to at least attempt to seat a jury, which is what the state asked for, which just seems to make sense because the 1959 citation that they had has had 2 subsequent rulings that negate it. So I don't know where you want up. Okay, you got to give me this first. Okay. Oh my God. So I'm not surprised by that at all. Oh, what's the milestone? Oh, member for yeah. Oh, thank you. I appreciate you, Bama. Bama Green Eyes. Shout out to the mods. They are amazing. Yeah, because it especially with the evidence that they provided, that could happen anywhere then, because they, like I said, they didn't give us any like geolocation of where all of this information was processed. Like, it's not like they had IP addresses of actually who read it. And sometimes people digest news and it goes in one ear and out of the other. Do you know? It's not like they're impacted by it. I mean, like I heard some case today, I don't know the young lady's name, but she like shot her manager at McDonald's. So, I mean, if I went in for voir dire and they asked, had I heard about that, I would say yes. I didn't form an opinion, or not shot, she stabbed her. I haven't formed an opinion about it. Do you know what I mean? It's just like I watch a lot of true crime content, so I probably would be knocked off like the woman in Sarah's jury selection. But you can't assume that everyone heard it, processed it, and then formed an opinion about it just because it was available to them. Like there's so much news. Like I'm like, oh, thank you, Jane. I appreciate you. So yeah, sorry I was late, guys. It wasn't incredibly muggy today, humid, and so Sugar Bear wanted to go to the park, and then we went and had dinner at Whole Foods. It's like something out of their hot bar, and time got away from us, so I didn't want to rush him. It's his second week in his new class. It was a little bit better this week, but it's still like he needs extra snuggles. She had her lover. Kathy is covering that if you guys want to know about Queen of Fupa. Gossip, rumor, and innuendo. She's got some great morning updates. If you're subscribed, you already know, but if not, go head over to Gossip, Rumor, and Innuendo, because she has some hilarious takes. This morning was especially funny. Yeah. If someone I know started covering a case in my county, nope, out of the coverage. Yeah. Yeah, because you'd want to be part of the jury pool, right? I would too. I actually got a jury summons, but now it's the 17th and I was going to go, but now I've got to cancel because I got my appointment on the 18th for my license. So I'm like, dang it. But hopefully I'll get, I'm one of those weirdos. But I feel like you need people like who have good critical thinking skills to be on juries. You know what I mean? So I don't think we should turn it down. I do take that civic duty seriously because, like, no offense to the jury, the Diddy jury, I don't think they comprehended a lot of it, or they just gave him like a OJ 2.0 pass. Because I'm like, what? But I know what they say: trust the jury, trust the community. Yeah, I just feel like we need people who can think, who can do deductive reasoning, critical thinking. So yeah. Oh, I did it too, but mine was like 8 years ago, it was a long one, which is why I was out of the pool for 8 years. So I'm excited to do it again. And I was the 4-person. Like it was a medical issue. So there was like a lot of testimony. And that's when I began being suspicious of the experts because they just totally contradicted each other. But it's like science is a theory, like medicine is a theory, right? They just came to completely different conclusions, and I was like kind of gobsmacked about it. Like, I guess whatever you pay them to say, not that they were being unethical, but I mean, you probably interview the people, and then the ones that says what proves up your case is what you put forward or supports your case. Like, I mean, well, no, I'm not even going to give Julie Harper a pass. I think she just made up stuff in Sarah's case anyway. Yes, sub to Kathy. Thank you, Bama Green Eyes. What I can. Oh my goodness. Are you on your feet all day? Bless you, Michelle. Okay, guys, I'm gonna go hang out with my little guy because he is needing some attention. Are we gonna play monster trucks? No, with the big blue truck. And I gotta get this thing out of his mouth. I don't want to chase him, but I don't want him to choke on it either. All right, guys, thanks for hanging out. I appreciate your patience, and I will talk to you later. Do you want to say toodles?
Yeah.
You gotta do this. Toodles. Bye, guys.